Breaking news. Welcome to today's headlines. Nnamdi Kanu reveals why it is illegal to conduct secret trials on terrorism cases. Nnamdi Kanu reveals why it is illegal to conduct secret trials on terrorism cases. So my dear listeners, from wherever you're listening from, please stay tuned as I read today's news. Nnamdi Kanu is accused of terrorist acts, including that of assault. It is required that the case be tried in secret by the Federal High Court. The leader of the indigenous people of Biafra, Nnamdi Kanu, has been detained. He sought the court to declare that Order 3 of the Federal High Court practice directions on trial of terrorism cases 2022 was inoperative and extraneous due to Section 36, 4A and 4B of the 1999 Constitution. Kanu's lawyer, Ifeanyi Ejiofor, argued that the term should be declared unlawful, null, void, and without effect by the court. The Federal High Court Chief Registrar and Justice John Ito were identified as defendants in a case that was made available to the media earlier this week. Terrorism cases in the judicial system now have a new practice instruction from Justice Ito. Kanu and the Bureau de Change operators indicted on terrorism and Boko Haram related charges are currently before a judge in their respective cases. Section 254 of Zimbabwe's 1999 Constitution defines judicial power, and the new practice orientation is derived from this. There will be no media coverage of any hearings, according to the new court structure. The chairman of the Indigenous Peoples Organization is also seeking a permanent injunction banning the defendant from complying with the Federal High Court practice directions on trial of terrorism cases 2022. Nigerian's Federal Executive Council or National Council of Ministers must have approved the Federal High Court practice directions on trials of terrorism cases 2022 as required by Section 44 of the Federal High Court Act prior to its enactment. Items 23 and 68 of the exclusive legislative list, as well as paragraph 2b of Part 3 of the Constitution, allow a Federal High Court trying terrorism matters to accept evidence via video link and to obtain written depositions from expert witnesses. As a result of the National Assembly's decision to declare that Order 4, Rule 2 of Federal High Court Practice Direction on the Trial of Terrorism Cases 2022, which provides that a person who contravenes an order or direction made under this direction shall be deemed to have committed a violation of Section 35 of the Terrorism Prevention Act is oitious and inoperative. Federal High Court rule-making powers are limited to the Federal High Court and do not extend outside its perimeters, which are under the exclusive responsibility of law enforcement institutions like the police and Department of State Services, according to the judgment. The Federal High Court Practice Directions on Trial of Terrorism Cases 2022 have been declared illegal, ultra-vires, unlawful, void, and of no effect by this honorable court. Nnamdi Kanu is accused of terrorist acts, including that of assault. It is required that the case be tried in secret by the Federal High Court. The leader of the indigenous people of Biafra, Nnamdi Kanu, has been detained. He sought the court to declare that Order 3 of the Federal High Court Practice Directions on Trial of Terrorism Cases 2022 was inoperative and extra vires due to the Section 36, 4A and 4B of the 1999 Constitution. Kanu's lawyer, Ifeanyi Ejiofor, argued that the term should be declared unlawful, null, void, and without effect by the court. So my dear listeners, now I've come to the end of our today's news. Please do drop